Hi, my name is Natalia, and I'm a real estate attorney here in the state of Florida. And today I want to talk to you about 3 title issues that investors face and how to fix them. So, number one issue that you see is you find a great property, it's fantastic, but the owner of record is deceased. So, what do? Well, in the state of Florida, in order to effectively transfer marketable title, you're going to have a probate action done. But there's generally 2 types of probate actions when it comes to transfer of property. There's summary administration and formal administration. Summary administration is the type of case that you want to have. It's relatively fast, although there are some counties that do take a substantial amount of time, such as Pinellas County, Florida. In those cases, if the person's been deceased longer than 2 years, and usually you can get a summary administration. Same thing, you can get a summary administration if the value of the estate is less than $75,000. Once you get to the point of formal administration, that's going to take quite a bit of time. It's going to be quite costly. So factor in those things before purchasing property that is under the title of deceased individuals. Number 2 title issue that you are going to see come up is when a mortgage is not satisfied of record, but the person who is the seller is telling you that they swear they paid it off. It's completely taken care of. So what happens is that generally homeowners have taken advantage of refinancing options throughout the years, and some homeowners have refinanced 4, 5, 6 times. And along that chain, there is a mortgage that just isn't satisfied. It's not that it hasn't been paid, it's just that the mortgage lender has forgotten to record their satisfaction. So what's your recourse there? Well, the first thing you can do is you can send a letter, try to contact the lender and say, hey, I need you to record your satisfaction. I'm aware that you were paid off in full when this subsequent mortgage was taken out. So that's one step. If they don't respond, however, sometimes you have to file an action for declaratory relief so that a judge can say, all right, let's provide notice to these individuals. If they don't respond, then we're going to declare that that mortgage is satisfied of record based on the chain that indicates that a subsequent mortgage paid off that prior mortgage. So there's that one. And then number 3 title issue that I see that frequently comes up is there's an error in the legal description. So you find this great house, you have sellers that are ready, willing, and able to convey title, and you hire somebody to do a title search and they tell you, hey, there's something wrong with the legal description. It doesn't match up prior chain legal, it doesn't match up the property appraiser legal. So what do? Well, in that case, it depends. So one, the error in the legal description could be just clerical. And if it's a clerical error, generally, if you get an affidavit from the person who prepared the deed, that'll be sufficient to address the issue. And you just have that affidavit recorded. There you go, fixes the chain of issue error. Other times, if the error in the legal description is material, so that means like they put in the wrong neighborhood, plat book, etc., or just the wrong legal period, then you're probably going to have to do an action to quiet title to get that issue corrected. There's also actions to have the legal description reformed, but it's probably more appropriate to have an action to quiet title to address that issue. And the lessons here is that you have to build in the costs and the time for repairing these title issues into your purchase price. So good luck out there, investors, and I hope these assist you in making determinations as to valuing those properties that you find.